Hey, good day. Welcome again to the Basic Philippine Law and Jurisprudence. We are again on the series of lectures on persons and family relations. So our topic for today is property regime of unions without marriage. So we are through discussing the different kinds of property regimes that may be entered into by the spouses before they get married. Now, how about those common law spouses or those who are living together without the benefit of marriage? What type of property regime will govern their relationship during their cohabitation? Now, Articles 147 and 148 answers that question. Okay, Article 147 tells us that when a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salary shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. So in the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work, or industry, and shall be owned by them in equal shares. A party who did not participate in the acquisition of any property shall be deemed to have contributed jointly if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common without the consent of the other until after the termination of the cohabitation. Okay, so this property relationship under Article 147 applies only to persons who are living together without the benefit of marriage but who are not suffering from any impediment to marry each other. Okay? They just live together without the benefit of marriage, but they are not disqualified from entering into marriage. Now, this also applies to void marriages. So, meaning parties who got married, but subsequently their marriage was declared void from the beginning. So, Article 147 tells us that during their cohabitation, okay, uh, the properties that they acquired shall be presumed to have been obtained through their joint efforts or industry, even if only one of them contributed to the acquisition of this property. Okay? And it shall be owned by them in equal shares. Okay? So that is Article 147. Okay. How about with respect to persons who are suffering from impediments to marry one another? What property relationship will apply to them? Article 148 tells us, in cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. Uh, in the absence of proof, their contributions and corresponding shares are presumed to be equal. Okay. If one of the parties is validly married to another, his share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his share shall be forfeited in the manner provided in the last paragraph of the preceding article. So if one of the parties suffer from any impediment, okay, to marry the other spouse, or if both of the parties are disqualified from marrying each other, it is Article 148 that shall govern. Okay, so in Article 148, only those properties that were acquired to their actual joint contribution, okay, shall be owned by them in proportion to their respective contributions. As opposed to Article 147, okay, the properties that were acquired during their cohabitation shall be owned by them in equal shares. And there is a presumption that even if only one of the parties contributed to the acquisition of those properties, okay, it shall still be owned by them in equal shares, even if the other spouse did not contribute but contributed through the keeping of the household. Okay, so in this case, it should be their actual joint contribution. The share shall be in accordance with their respective contribution unless there is, in the absence of proof, however, it is presumed to be equal. So whoever alleges that his contribution is more than the other partner has to prove the same. Okay? We now go to the cases. Ocampo versus Ocampo. In a void marriage, as such as those under Article 36, the property relationship is governed either by Article 147 or 148. So it would depend on whether the one or both of the parties is suffering from any impediment to marry the other spouse. Article 147 applies to union of parties who are legally capacitated and not barred by any impediment to contract marriage, but whose marriage is nonetheless void. Okay? I repeat, 147 and 148 does not only apply to common law spouses. It also applies to parties who got married, but subsequently their marriage was declared void ab initio. Okay. If, for example, the ground for declaration of the marriage is that it is a bigamous marriage, then it is Article 148 which will apply. Okay. On the other hand, if the ground for the declaration of the nullity of marriage is psychological incapacity, then it is Article 147 which will apply. Okay. For Article 147 to operate, the man and the woman must be capacitated to marry each other and live exclusively with each other as husband and wife. Their union is without the benefit of marriage or their marriage is void. So the term capacitated pertains to legal capacity of a party to contract marriage. Okay, so in this case, the marriage was declared void under Article 36 of the Family Code. Okay, so Article 147 will apply. Efforts in the care and maintenance of the family and the household are regarded as contributions to the acquisition of common property by one who has no salary or income. While it may be true that the management of the businesses referred to may have been actively undertaken by the petitioner, it cannot be gainsaid that petitioner was able to do so without the invaluable help of the respondent. Even a plain housewife who stays all the time in the house to take care of the household while the husband indulges in lucrative and gainful activities is entitled to a share in the same proportion the husband is to the properties acquired during the marriage. We have the case of Marido versus Nonato. So in this case, Nonato and Marido's marriage was declared void under Article 36 of the Family Code. Okay? In this case, any impediment to marry has not been shown to have existed on the part of either spouse. They live exclusively with each other as husband and wife. However, it was declared void on account of psychological incapacity. incapacity. The former spouses both agree that they acquired the subject property during the marriage, thus it shall be presumed to have been obtained by their joint efforts, work, or industry. So Article 147 applied to that case. Okay, Dino versus Dino. Okay, the issue in this case is whether the trial court erred when it ordered that a decree of absolute nullity of marriage shall only be issued after the liquidation, partition, and distribution of the parties' properties under Article 147 of the Family Code. So it also discussed what are the requirements for Article 147 to apply. The man and the woman must be capacitated to marry each other. They live exclusively with each other. Their union is without the benefit of marriage or their marriage is void. So all these elements are present in this case. So the trial court erred in ordering that a decree of absolute nullity shall be issued only after the liquidation, partition, and distribution of the parties' property. Article 50 of the Family Code does not apply to marriages which are declared void ab initio under Article 36, which should be declared void without waiting for the liquidation of the properties of the parties. Okay? Next case is Dultra versus Baclot. So Sancho and Crescencia entered into a common law marriage, while the former's marriage with petitioner was valid and subsisting. So clearly, Sancho was incapacitated to marry. Okay, so the cohabitation between Sancho and Crescencia is governed by Article 148 of the Family Code. So the ownership of the properties jointly acquired by the parties who are cohabiting is in proportion to their respective contributions, which require actual proof. In the absence of proof, they are presumed to be equal. Okay, it must be stressed that the actual contribution is required by this provision, as opposed to Article 147, which states that efforts in the care and maintenance of the family is regarded as a contribution. So if the actual contribution of the party is not proved, there will no longer be co-ownership and no presumption of equal shares. So in this case, the subject properties were registered in the name of Crescencia alone. Okay, the claimant must nonetheless prove his title in the concept of an owner. Respondents failed to introduce evidence that Sancho is a co-owner. Crescencia is a mere dressmaker who cannot afford the subject properties, is a scourge to her industry and a condescending presumption. So the subject properties were under the name of Crescencia alone. Failure to show that Sancho made actual contributions in the purchase of the same, the court is bound to declare that Crescencia is the exclusive owner of the subject properties. Okay? Ventura versus Paulino. For in this case, Edilberto admitted that in unions between man and a woman who are incapacitated to marry, the ownership over the properties during the subsistence of that relationship shall be based on actual contribution. So in this case, it is necessary to prove the actual contribution of the parties. Presumptions of co-ownership and equal contribution do not apply. So applying the said provision, the Vitas and the Delpan properties can be considered common property if these were acquired during the cohabitation and there is evidence that the properties were acquired through the parties' actual joint contribution. So however, the title itself shows that the said properties is owned by Esteban alone. The evidence shows that Esteban acquired ownership over the Vitas property prior to his marriage to Socorro. On the other hand, Edilberto failed to show any evidence showing his alleged monetary contributions. Okay. The case of Bangayan versus Bangayan. Benjamin and Sally cohabited without the benefit of marriage. So only the properties acquired by them to their actual joint contribution will be considered common properties. So both the trial court and the CA correctly excluded the 37 properties being claimed by Sally, which were given by Benjamin's father to his children as advance inheritance. Only the property covered by TCT number 61722 was registered in the name of Benjamin and Sally as spouses. We have ruled that the words married to preceding the name of a spouse are merely descriptive of the civil status of registered owner. Such words do not prove co-ownership. Without proof of actual contribution from either or both spouses, there can be no co-ownership. So this case of Bangayan tells us that despite the registration of a property in the name of both spouses, there is still a need to prove actual joint contribution. Okay? Mendoza versus Mendoza. So in this case, Belen and Renato were not capacitated to marry each other because Renato had a subsisting marriage to Angelina. Okay, their property regime is governed therefore by Article 148, which applies to bigamous marriages, adulterous relationships, relationships in a state of concubinage, relationships where both man and woman are married to other persons, and multiple alliances of the same married man. Okay, only the properties acquired by both parties to their actual joint contribution of money, property, or industry shall be owned by them in proportion to their respective contributions. Proof of actual contribution is required. Now, the co-ownership will only be up to the extent of the proven actual contribution. Absent proof of the extent, their contribution shall be presumed equal. Okay? Although the cohabitation commenced in 1981, way before the effectivity of the Family Code, Article 148 still applies because this provision was intended to fill up the hiatus in Article 144 of the Civil Code. In other words, it is curative legislation. So it can be made to apply retroactive. So in this case, Renato is valid to and married to Angelina. His share in the co-ownership or in the absolute or conjugal partnership is existing in such valid marriage. Okay, next case is Perz versus Senera. The issue in this case is whether the gratuitous disposition of a property acquired during a common law relationship or cohabitation of a man and a woman without the benefit of marriage or under a void marriage requires the consent of both as is required from a lawfully married couple. Remember, in gratuitous disposition, okay, because it involves acts of ownership. Okay? It is necessary that both spouses, in case they are validly married, okay, give their consent to the said donation. Is it also true with respect to unions without marriages or those unions under a void marriage? Okay, so in this case, Eliodoro and Adelita were the owners of a parcel of land. Now, there was a sworn statement called renunciation and waiver of rights executed by Adelita in favor of her husband, Eliodoro. Now, Eliodoro donated the said land to Nixon without the conformity of Adelita. Now, whether the CA erred in ruling that the property regime of Eliodoro and Adelita is covered by the absolute community despite the final decision declaring their marriage void ab initio. Okay? The Supreme Court said that Nixon correctly cited Article 147 as the applicable property regime, okay, during their common law relationship. The subject property was registered in the names of Eliodoro and Adelita as spouses, there being no proof to the contrary, the subject property is presumed to be obtained by them through their joint efforts, work, and industry and owned by them in equal shares under Article 147. Okay, however, every donation between the spouses during the marriage shall be void. So this provision shall also apply to persons living together as husband and wife. The purpose of this provision is to protect third persons who may have contracted with a spouse, believing the existence of certain properties. Okay, the renunciation and waiver of rights is also void because the sale between the spouses during the marriage is prohibited under Article 49. The consent of both spouses is required whether the disposition is gratuitous or onerous. If the a disposition of a party share under special co-ownership created by virtue of Article 147 without the consent of the other parties prohibited, then with more reason should the disposition of the entire property under such special co-ownership by a party without the other parties be concerned be considered void as well. Okay? We now have the case of Atienza versus Decastro. This is another case of property of a union where the one of the spouses is not capacitated to marry the other. In this case, Lupo, being a married man, he and Yolanda lived together. However, their relationship turned sour, so they parted ways. Now, Lupo filed a complaint for the judicial partition between them of a parcel of land. Lupo alleged that the subject property was acquired during his union with Yolanda as common law, husband and wife. Hence, the property is co-owned by them. She insisted having bought it through her own savings and earnings as a businesswoman. Now, the parties were not capacitated to marry each other, and therefore Article 148 will govern. Co-ownership will be only up to the extent of their actual joint contribution. Absent proof thereof, it shall be presumed to be equal. Petitioner's claim of co-ownership is without basis because not only did he fail to substantiate his contribution, but likewise the very trail of documents redounds to the benefit of the respondent. Respondent was able to present preponderant evidence over her sole ownership. Okay, so what is important in Article 148 is proof that the property was not a common property but a property which is owned solely by one of the partners. Benasa versus Mahor. So in this case, Benasa and Mahor were childhood sweethearts. However, Mahor eventually married another man. On the other hand, Benasa remained single and became a seafarer. Okay. While Mahor's marriage subsisted, they reunited and engaged in an adulterous relationship. Benasa asserted that using the salaries and benefits that he regularly remitted to Mahor in monthly allotments, the latter was able to purchase several real properties. However, these properties were registered only in the name of Mahor. Okay, so he requested Mahor to make an inventory and accounting of all the cash remittances. However, he refused. Now, Benasang filed a complaint for inventory, accounting of money, properties, okay, against Mahor, but the same was denied on the ground that the parties must cohabit or live together as husband and wife. So what transpired between Benasa and Mahor was not the marital cohabitation contemplated under the law, but a simple love affair. Now, what do you mean by the term cohabit? It means to dwell together in the manner of husband and wife for some period of time, as distinguished from occasional, transient interviews for unlawful intercourse. Okay, verily, as petitioner was able to substantiate his claim that he and respondent were cohabiting as husband and wife under Article 148, the properties acquired by them during their cohabitation shall be co-owned by them in proportion to their actual respective contributions. So in this case, petitioner is a seafarer and he has maintained his relationship with respondent. In the course of his employment, petitioner has to perform his work overseas. That will not allow him to stay in a dwelling for which he may spend a longer period of time. Under such situation, it becomes important to take into consideration the intent of the petitioner to return to the place where he considers as his residence or dwelling with the respondent. Okay, so the court construed the same also as cohabitation. So since they suffer from impediment to marry each other, proof of their actual joint contribution to the properties was required under Article 48. So that is for property unions without marriage. That is all. Thank you for listening.